Good morning and welcome to the second session this morning of Tennessee Supreme Court here at Boys State. Our Scales project, Supreme Court Advancing Legal Education for Students, brings together judges, attorneys, and students to develop a better understanding of the judicial branch of government and the role of the courts in our society. Unlike cases you see on TV, as Mr. Hivner said, today you will hear real cases with real lawyers representing real clients and real judges deciding these issues. We appreciate your participation and we hope that you enjoy the case you will hear today. I want to thank Tennessee Tech University and Dr. Philip Oldham, President of the University, Jason Murphy, the Tennessee American Legion Boys State Chairman, and Judge John Maddox, Vice Chairman, and all of the delegates and staff at this year's American Legion Boys State who have worked so hard to make this event possible. I also would like to thank the following law enforcement agencies who are assisting us with our security for today's program: the Tennessee Highway Patrol, Cookeville City Police Department, Putnam County Sheriff's Department, and Tennessee Tech University Police. Also, Putnam County Emergency Medical Services. Thank you as well to the attorneys who are arguing these cases today. I know it took extra effort for you to get here. It's not a short distance from where you traveled to these cases. I appreciate that. We hope all of you students will stay engaged with the judicial branch after court today. You can follow us on Twitter at TN Courts, on our website, tncourts.gov, and on Facebook. The opinions we write on today's cases will be posted to our website and to our Twitter feed. Now I want to introduce you to the justices of the Tennessee Supreme Court. To my immediate right is Justice Sharon Lee, a past Chief Justice of this court. She is a graduate of the University of Tennessee with a degree in accounting and the University of Tennessee College of Law. She practiced law in her hometown of Madisonville before being appointed to the Court of Appeals in 2004. She was the first woman to serve on the East Tennessee Court of Appeals. After serving on that court for 4 years, she was appointed to the Tennessee Supreme Court in 2008. She is from Monroe County. Next is Justice Jeff Bivens. He is also a past Chief Justice of this court. He is a graduate of East Tennessee State University with a major in political science and a graduate of Vanderbilt University School of Law. He practiced law in Nashville, served as Assistant Commissioner and General Counsel for the State of Tennessee Department of Personnel. He has served as a trial court judge and a judge on the Tennessee Court of Criminal Appeals. He has been a justice on this court since 2014. He lives in Franklin. Justice Holly Kirby graduated from the University of Memphis with a degree in engineering and from the University of Memphis School of Law. She clerked for a federal appellate judge and then practiced law in Memphis. She was the first woman appointed to the Court of Appeals in Tennessee. She served on the Court of Appeals for 19 years before being appointed to the Supreme Court in 2014. She lives in Memphis. Justice Sarah Campbell is a graduate of the University of Tennessee. She's on my far left. She studied political science there, educational policy, and Spanish. After attending Duke University School of Law, she clerked for a federal court of appeals judge and a U.S. Supreme Court justice. She practiced law in Washington, D.C., and has served as an associate solicitor general and special assistant to the Tennessee Attorney General. Justice Campbell was confirmed as the court's newest justice earlier this year. She lives in Davidson County. I am Chief Justice Roger Page, and I am a graduate of the University of Tennessee College of Pharmacy and University of Memphis College of Law. I practiced law for 14 years before being elected circuit judge in 1998. I was appointed to the Court of Criminal Appeals in 2011 and the Supreme Court in 2016. I live in Chester County. As you can see, we are from different parts of Tennessee and went to different law schools. We all consider it a great privilege to serve on the highest court of this state. We are committed to upholding the Constitution, protecting individual rights, and applying the laws of this state. And we're almost ready to go to work on the second case this morning. Of course, each side has 30 minutes. If the appellant wishes to reserve rebuttal time, let me know that when you approach the podium. Mr. Jim Hivner, who is our appellate court clerk and well known to all of you now, will call our first case.
Henry Lawson et al. Versus Hawkins County, Tennessee et al.
Good morning, Your Honors. I'd like to reserve 10 minutes for rebuttal, please. I'm Jeff Ward with the law firm of Milligan & Coleman from Greenville, Tennessee, and I'm representing Hawkins County, Tennessee, and Hawkins County Emergency Management Agency, Mr. Russell Adkins was supposed to be with me today for Hawkins County Emergency Communication District that I'll refer to as Hawkins County 911, and he was planning on presenting arguments as well, but unfortunately he's tested positive for COVID in our current COVID climate, so he is going to rely upon his briefs and upon my arguments. This case arises out of a very tragic accident that occurred resulting in the death of Mr. Steve Lawson. And Mr. Lawson was unfortunately traveling across Clinch Mountain on a state highway, State Highway 70, toward Hawkins County and Rogersville when an event resulted in his death. So it was back on February 21, 1999 when this occurred. And early in the morning hours, just a few minutes before 1 a.m. in the morning, a citizen called in and reported that trees were down on that state highway and that part of the road was cut off. In response to that, 911 dispatchers sent out a deputy to investigate the situation. The deputy goes toward that area coming from the Rogersville side of it and goes up the state highway and encounters a tree down across the road, blocking the road. At that point, when he's assessing the situation, he notices that mud is sliding down the side of the mountain, and it's even pushing a power pole in that location. The tree blocking his access to the road prevents him from going any further, so he doesn't know at that point what's going on further up the road, further up Clinch Mountain. But what he does is call back into 911, advises the 911 dispatcher of the situation, and discusses that situation with the dispatcher. Since it's a state route, or state highway, the dispatcher's already contacted the Tennessee Department of Transportation as well, advises the deputy that someone from the Department of Transportation is en route and will be coming to that location. Also advises that the electric company has been contacted in order to assess the power pole issue that's involved. So at that point, unbeknownst to the deputy, further up the road, further up the mountain and around the curve and up the mountain, there's an area of the road that's actually been washed out and collapsed as a result of that mudslide. And that's the area that Mr. Lawson, coming the opposite direction, encountered, and unfortunately at that point his vehicle goes through the collapsed area down into the ravine and ultimately results in his death. As a result of his death, his widow, Ms. Lawson, has brought a lawsuit, and that lawsuit has raised claims based upon negligence, gross negligence, and reckless conduct. And so we're here today on the legal issue related to those claims, with the primary first legal issue being whether or not Penny Lawson can actually sue Hawkins County and the other governmental entities for conduct that rises above the level of negligence as it relates to any employee of any of the governmental entities. And as this court's well aware, and in fact, as Justice Bivens pointed out in our first set of arguments this morning, sovereign immunity applies to any governmental entity unless that sovereign immunity has been specifically lifted by the legislature. Here, we're talking about what's called the Tennessee Governmental Tort Liability Act, referred to as the GTLA, and there are certain provisions that the legislature has enacted to lift that sovereign immunity under limited circumstances. The only one of those that's specifically at issue in this case at this point is Tennessee Code Annotated 292205, which importantly lifts immunity of the governmental entity for the negligence of its employees. And that the language in that statute is specific as to injuries proximately caused by the negligence of an employee arising out of the scope of that employee's actions. And it's important when we're talking about that to look specifically at that language and look at what this court has said has to be done with that waiver of sovereign immunity, as well as what the legislation itself says about the waiver of sovereign immunity. And both of those, this court says based on common law application, anytime sovereign immunity is going to be waived, the statute waiving that has to be strictly construed. And the legislation itself in the GTLA says strict construction is required. So looking at that language and applying that language to the strict construction standards is what we're really talking about here today, and really what the defendants are relying upon to say the Court of Appeals in this decision was just got off the mark with respect to that application. The court looked at interpreting that statute, but instead of specifically looking to strictly construe it, the court construed it in what the court believed was a reasonable manner and what might be legislative intent, as opposed to applying a strict construction that would hone in on the limitations on sovereign immunity, as opposed to expanding that in some way. In doing that, the Court of Appeals essentially didn't really look at the language that this court has used in defining gross negligence and recklessness in a manner that's different than and added to an underlying simple negligence standard. And most telling is the court's, this court's language as far as recklessness and the severe difference between it and a simple negligence standard. And I think, the court's opinion in Doe versus Roman Catholic Diocese of Nashville is telling, because the court here said, recklessness is a hybrid concept which resembles both negligence and intent. It's distinct from both and can be reduced to neither. And then went on in that same area to say, nevertheless, recklessness contains an awareness component similar to intentional conduct, which is not demanded of negligence. So the defendant's position is, when you're looking at the clear differences between recklessness and recklessness or gross negligence requiring something additional to negligence, it can't be a strict interpretation of that clear language in the statute of negligence of an employee to say that negligence encompasses something greater.
Mr. Ward,
Yes.
Can we construe the plaintiff's complaint here to be alleging ordinary negligence?
You can, I think you can construe the complaint to allege ordinary negligence, gross negligence, and the trial court said it can be read broad enough with the facts alleged to even include recklessness. And in front of the Court of Appeals, the defendants asserted that really there weren't enough facts asserted to go down the recklessness line, but the Court of Appeals said there was, and we have not raised that for this court. We wanted to focus for this court's purposes on the real legal issue of, can you sue a governmental entity for the recklessness of an employee to begin with?
If we were to hold that negligence or negligent act or omission in subsection 205 does not include recklessness or gross negligence, would this need to go back to kind of sort out what claims exactly may proceed, or did the trial court already determine that?
The trial court already determined that. So what the trial court did was the trial court agreed with our position and said, yes, the governmental entity cannot be sued for anything above the negligence of an employee. And then the trial court at that point went to phase two, which phase two is our discussion about the public duty doctrine. Mm-hmm. So we would say if this court agrees with our position, we still have to go to phase two to see if Ms. Lawson can actually proceed on the negligence claim against the governmental entity, or whether that claim is barred by the public duty doctrine.
Well, and that's where I'd like your help a little bit, because I think that's where it gets a bit confusing when we've got the overlap there, and we're trying to figure out which claims fall within this third special duty exception and how that works in relation to subsection 205. So I'd like you to help me understand just what is the nature of the claim that may actually proceed under that third exception. As I understand it, and I may be wrong, it would be a claim against a municipality alleging that the government employee's negligence proximately caused an injury that itself arose from recklessness or something.
And we would
higher.
We would disagree with that.
Okay,
So
help me understand your position on that.
Yes, our position would be, step one is look at the claim to breach to begin with, and what is that? Is it negligence, is it gross negligence, or is it recklessness? And if it's something above negligence, then that can't be pursued against the governmental entity itself. It could be pursued against an individual. Mm-hmm. So there are many cases that a lawsuit will be filed against the governmental entity and will also name an individual defendant. If you look back at our Azell case, which is that seminal public duty doctrine case, that was a circumstance there, that the actual suit was against the governmental entity and against the chief of police, and the chief of police was the one who had encountered the people under the influence and ultimately decided to let one person drive from the scene that then later resulted in the car accident and the death.
So public duty doctrine is going to apply if you've got, whether the claim is against an employee or against the municipality.
Correct.
In
that Azell case, they looked at both claims and said both the entity and the individual were entitled to the protection of the public duty doctrine. Now, that case, there was not an allegation of recklessness, so the court there didn't have to say, okay, the recklessness allegation there's enough here to allow that to proceed. And I think if the court had that, the court would have said, okay, that recklessness claim then can proceed against the chief of police,
So
but
is there
not
any,
against the entity.
I guess, is there any claim that would fall, that would fall within the third special duty exception and be permitted against the municipality under subsection?
Special duty exception as to the other negligence component. For example, in Limbaugh, there it was an intentional tort, but it was allowed to proceed because there was a claim of negligence against the entity for not preventing that assault. And there, public duty doctrine wasn't raised because it was clear that the first exception applied. They'd undertaken a special duty to protect in that setting of a mental institution where they're protecting the people that are there. Same thing would apply in a jail setting where that special duty is already in play.
So if we're talking about just the third special duty exception alone, it would be your position then that that really has no application when we're dealing with a claim against the municipality?
Correct, unless there's another special duty as to the negligence part against the other employee. So if you've got one employee that acts recklessly, if I can say it, and then you've got another that's negligent and allows that, then you would then be looking at that negligent conduct and seeing if there's a special duty exception that would apply to it.
But there would have to be a separate special duty exception
But there would
that
have to be
applies to that
something separate.
negligence.
Yes, Your Honor.
Okay.
Otherwise, you're letting the case proceed as to any claim based upon one special duty related to another aspect of the claim, which I would submit is a very slippery slope, because if that were the case, the court in Ezell could have said, well, it was reckless for this person to drive this vehicle, and because that claim is based upon recklessness of that person, you can now pursue negligence of any entity or any person.
Don't the exceptions that fall under subsection 205, though, sort of contemplate that you could have a claim for, let's say, negligent supervision or negligent training that where the injury is actually directly caused, so setting aside the proximate cause piece of it, where the injury is caused by something other than negligence, caused by recklessness or an intentional tort?
Yes, I think so. There are certain exceptions that say you can't pursue a negligence claim even if these torts or other events occur, and some of them are referred to, like negligent inspection or intentional failure to inspect. So in those kind of settings, they're specifically carving out those areas and saying, even if it's a negligence claim, you can't pursue it as to these type of things. And that's where Limbaugh, the court said there wasn't a specific exception as to assault. So if there's a negligence claim, you can pursue the negligence allowing the assault. It just didn't get to the public duty doctrine portion because there was already a special duty exception that applied to the negligence claim based upon the setting.
Can I bring you back
Absolutely.
to 29-2205, the first part where it removes immunity for injury proximately caused by a negligent act or omission. I understand the premise that this is construed strictly, but not unnaturally. It just says negligence. Is your argument that that cannot, I mean, I don't know what gross negligence is, except it's like really, really negligent as opposed to a little negligent. And so how do you exclude gross negligence from that? And if so, how?
I would exclude gross negligence from it just because of the basis of the court's definition of gross negligence as requiring almost the same level of willful disregard as this court has talked about in recklessness.
But not.
But not quite.
Gross negligence is not the same as recklessness,
right,
is it?
But it's clearly requiring something more than simple negligence. And so my position, Your Honor, would be...
But this doesn't say mere negligent act, simple negligent act. It doesn't denote the type of negligence involved, does it?
It doesn't, Your Honor. And so this court could say that the reference to negligence could include gross negligence.
And it's pretty hard to differentiate, isn't it, between gross negligence and so, I mean, where do you, and here you're talking about whether a lawsuit gets to go forward. And that very mushy, you know, what's a little negligent as opposed to a whole lot of negligence?
Yes, and Your Honor's correct. The one caveat I'd give to that is when we're talking about that strict construction and strictly construing sovereign immunity, an interpretation allowing that to be included expands the lack of
Well,
immunity
that's
as
my
opposed to
point.
contracting
Does
it.
it expand, or is it just reading it naturally? It just says negligence. I mean, we're not supposed to we're not supposed to add words to the statute. We're not supposed to restrict it artificially.
So this court could certainly say that you're not adding or restricting by saying this doesn't limit it to mere or gross. The problem for this case is, as far as closing the door is still closed, because from the public duty doctrine standpoint, it's got to be more than negligence of any type. It's got to be recklessness, intent, malice for that third exception.
Well, we have more than one employee's conduct at issue, though, right? Because we have that many of the allegations are, well, they hired family members, they didn't train them. All of that has to do with the employees who do the hiring and firing and are responsible for the training, as opposed to just the deputy who was at the location or the dispatcher.
Yes, and that went back to my argument with Justice Campbell's point of, if you're looking at those separate sets of negligent acts, we would submit that each one of those has to have an exception for it. Otherwise, you're allowing the special duty for one thing to allow blanket suit as to any and all governmental entities and any and all parties that are involved.
Right, this is clearly going to require a big diagram.
Right, right.
Okay.
And so we think the reading of the cases is that if there's a special duty exception under the public duty doctrine, that allows that duty to be pursued, the breach of that duty, but doesn't necessarily allow the breach of any other duty to be pursued unless there's some other special exception that would apply to that as well. So our position essentially would be a strict construction would limit this and say, clearly reckless conduct can't be construed as part of negligence. It's a very much closer question as to whether gross negligence should be considered, but that doesn't get past the public duty doctrine anyway in this case.
What about reckless conduct when it comes to the public duty doctrine? If we decide that has been pled and can be possibly proven here, does that get us back to negligence again?
It doesn't. That's the problem is it doesn't get you back to opening the door to negligence, because that negligence claim is a separate claim for which there's no separate special duty. And so you've got two different claims, one that could proceed, but we would submit could only proceed as to the individual. And the Court of Appeals had this public policy argument that somehow allowing this would encourage governmental entities to ramp up their level of conduct, making it worse, which respectfully doesn't make a lot of sense, because
well, it does. It does indicate, though, that the governmental entity would argue that their own employees' conduct was worse than negligence, right? I mean, it's not going to affect their conduct in the moment when the incident is going on, but it would create the odd situation of a governmental entity saying, no, our employee was really bad, it was reckless, he was aware of the danger and proceeded.
you certainly could have that arise. And that has arisen.
That's counterintuitive, right?
In those, well, it arose in the Hughes case that this court considered, where the determination was, did this person driving this vehicle intend to cause injury or to scare the person that's walking? It was a practical joke kind of setting. But the question was, is this an intentional act or is it just negligence? And so in that case, the court said, no, this was intentional, even though it didn't intend harm, intended to cause that fear. And so it was intentional conduct, and they could only pursue the individual. The Hart case and the Spearman case that the Court of Appeals addressed Hart, but did not address Spearman at all. And Spearman was a case where it was a shot putting situation where I think a coach was throwing a shot put and it injured one of the students. And there the assessment was, and the Court of Appeals said, if it's something more than negligence, if it's gross negligence or if it's recklessness or intentional, then you can't pursue the entity. You'd be limited to pursuing the individual. And so went through the whole assessment of what is this conduct and determined if this was just negligent conduct. And in that case, the public duty doctrine really wasn't at play, because clearly there was a special relationship with the student involved. So the public duty doctrine didn't come in. And I think I'm out of my time until my rebuttal.
You have 10 minutes in
Thank
rebuttal.
you.
May it please the court. I'm Tom Seeley from Seeley & Mays in the Washington County Bar. I represent Stephen Lawson, who died February 21st, 2019. I represent his widow, Penny Lawson, and I represent their son, Corey Lawson. The courts in Tennessee have set forth a framework for analyzing claims against governmental entities and their employees. In analyzing Ms. Lawson's claims against all three defendants, first you must consider whether immunity has been removed under the Governmental Tort Liability Act, the GTLA. If immunity has been removed under the GTLA, then the courts must look to the public duty doctrine and the three special duty exceptions. If the special duty exception applies and the public duty doctrine defense is removed, then the claim should proceed forward. And looking at Ms. Lawson's claims specifically against 911, immunity has been removed under the GTLA. TCA 2920-108 removes immunity from emergency communication districts for gross negligence or willful misconduct if they have not attained and maintained training requirements as required by state law. Lawson's complaint asserts that 911 failed to attain and maintain training requirements. Her complaint asserts the claim for gross negligence of 911 employees. Then under TCA 2920-205, it removes immunity caused by negligent acts or omissions of employees within the scope of their employment and negligent training and supervision of those employees. Our complaint asserted negligent training and negligent supervision of the 911 employees. There's also TCA 786-320, which is outside of the GTLA but establishes emergency communication districts. That statute removes immunity for emergency communication districts for claims of reckless or intentional misconduct in processing emergency calls. Our complaint asserts recklessness in that the employees failed to obtain any information to assess the danger, and they failed to take any action to stop traffic that was traveling southbound on Highway 70. So Lawson's complaint does assert claims for failure to supervise, failure to train, and failure to maintain licensing requirements. This resulted in their employees' reckless behavior. They failed to take any action to stop the southbound traffic. So immunity for 911 has been removed under the GTLA, and immunity for 911 has been removed under TCA 786-320 because recklessness was also pled in our complaint.
So, Mr. Seeley, let's address that for just a second. So you're claiming with regard to the negligent hiring, negligent training, negligent supervision, that was mere, as we refer to it, as mere negligence, or are you saying that that was reckless?
That was negligence, Your Honor.
Okay.
The failure to train and failure to supervise. And again, that is sufficient that was asserted in our complaint, and that does remove immunity for 911 under the GTLA. And then again, that caused the reckless conduct of the employees when they gathered basically no information to assess the situation on Highway 70 that night. Then they took no action to stop traffic that was traveling southbound, which was the direction Mr. Lawson was traveling when he came across the mountain, and there was no highway there. It had completely washed away. So again, that removes the immunity under the GTLA, and we asserted that in our complaint. And again, it shouldn't take a complicated diagram in order for us to navigate through the GTLA and the public duty doctrine.
Well, how do you get around the public duty doctrine if you proceed on negligence and immunity is waived? How do you get around the public duty doctrine at that point?
Because the negligence of the entity then resulted in the reckless conduct of their employees, Your Honor.
And that's why you are pursuing gross negligence and recklessness to avoid the public duty doctrine.
Correct, Your Honor.
And that's really the only way you can prevail is to ramp that conduct from negligence to recklessness. That'd be fair to say, or gross negligence.
And I think that's correct. And I think that's one of the steps the Court of Appeals, again, addressed when they did say that they believed that immunity was removed for negligence, gross negligence, and recklessness to say that, again, we have this foundational element of negligence, this deviation from the standard of care. That deviation from the standard of care exists in gross negligence and recklessness. That's the key element that runs through those. And I think that's what the Court of Appeals relied on, that says, again, immunity should be removed because that has been asserted. But I think you're right. We've asserted that, again, because the negligent supervision, negligent training removes the immunity, then that caused the reckless conduct. That allows us, even under the defendant's theory, to proceed forward.
Well, let me probe that a little bit to follow up on Justice Lee's question a little bit. You've got negligent hiring, negligent supervision, negligent training, and you said, and that resulted in the recklessness of the individual employee who was making the decision. Recklessness is differentiated from either negligence, any kind of negligence, regular negligence, gross negligence, whatever, by the fact that the actor knows what ought to be done, knows the standard of care, and chooses to ignore it. So if you're talking about negligent hiring, negligent supervision, you're basically saying you didn't teach these people what to do. But if the individual employee is reckless under the exception to the public duty doctrine, he knew what to do and just didn't do it, just chose not to do it. You see what I'm saying?
Yes, Your Honor, but I think it's a situation with recklessness where the employee maybe had a conscious disregard of the risk.
Okay.
And
I am aware that this is at a very early pleading stage, and we are supposed to look very generously at the pleadings. And it might be that one decision is made at this juncture, and then later, after the proof develops, whether there's actual proof of recklessness on the part of the individual employee, that may be something that is better determined down the line.
And for the purposes of the stage we're at in this proceeding, again, we have asserted a claim for recklessness. The trial court found that. We
Gotcha.
have asserted a claim for negligence and a claim for gross negligence.
Okay.
And Mr. Seeley, would you agree that the Court of Appeals erred at least when it said that gross negligence was sufficient to come within the special duty exception?
That gross negligence came within the special duty exception?
Yes. That gross negligence can get you within that exception, as opposed to recklessness.
Your Honor, to draw this distinction between gross negligence and recklessness, I think really highlights the problem that the court's dealing with. And I think, again, there's a point that this is on a spectrum that there's no way to draw that line between gross negligence and recklessness.
So
and
your
again,
answer is they did not err?
They did not err in that, Your Honor. Again,
So despite the fact that taking it out of the sovereign immunity standpoint, the courts have all the time make distinctions between regular or ordinary negligence, gross negligence, and recklessness. For example, on punitive damages, correct?
yes, Your Honor.
So despite the fact that those distinctions are made all the time, those distinctions don't mean anything in the context of sovereign immunity, which is supposed to be strictly construed.
Again, I don't think those distinctions with regard to punitive damages, again, there's a line drawn between where if you've asserted...
I'm just using punitive damages as an example. There are many other examples where those distinctions are made in other areas of the law.
But if what we're relying on is to say a claim that asserts recklessness is dismissed while a claim for gross negligence can go forward, then again, I defy any court to draw that line and show me where one starts and one stops. And I don't think that can be done. And again, we know at some point we can probably distinguish between mere negligence and reckless behavior. But what I would point to the court is, again, the key element of negligence, gross negligence and recklessness, is the deviation from the standard of care. And again, with the recklessness, we do get the conscious disregard of risk. But we should not be having to navigate this labyrinth in order to go forward. And the court shouldn't be trying to make a distinction between gross negligence and recklessness that determines whether a complaint can go forward or is dismissed. Again,
Or you're just focusing on the fact that this is such an early stage and we're just looking at the complaint.
I think that's a big part of it, but I think if you look at the trial court's opinion, again, I don't think the analysis followed the structure that's been set forth where you're actually considering removing immunity under the GTLA and then considering the public duty doctrine. We ended up with the situation where we've asserted negligence and that can't get past the public duty doctrine. We've asserted recklessness, but that can't get past the GTLA. And I believe that's the way the trial court looked at that. And so again, that's what we're asking this court to clarify and move us away from these inherent contradictions sometimes that arise when you're considering the GTLA and the public duty
This
doctrine.
is a brain herder, that's for sure.
It really is, and that's what you struggle dealing with, these exceptions within exceptions. And I do think if you look to the legislative intent when we're looking at the GTLA, the legislature has said, and their intent was, they're removing immunity for governmental entities and their employees when they've deviated from the standard of care. And I think if the court looks at the logic of a more recent case, it was the city of Maryville case dealing with the defective sidewalk, and where they said, again, they looked at the GTLA and the removal of immunity for defective sidewalks, and then said, well, none of those cases can ever get past the public duty doctrine. Surely that makes no sense. And I think we're seeing these situations that the juxtaposition of those two doctrines, again, oftentimes leaves us with an absurd result.
But doesn't that ignore, to some degree, the fact that claims can also be brought against employees themselves in certain instances? Because, I'll admit that your kind of argument about this being a bit of a catch-22, is somewhat persuasive when you look at claims against the municipality in isolation without considering, that claims can also be brought against employees. What's your kind of response to that? Doesn't looking at claims against the employees kind of resolve that seemingly absurd result?
I think from a policy standpoint, the governmental entity is best situated to handle and redress the injuries that are caused by their employees. And I think most employees in this situation, again, are not going to be able to, again, allow a plaintiff to really seek redress against those employees. And I think it would have a chilling effect on anyone that wanted to serve a governmental entity, if that was your recourse, is just to sue the individual. And so again, I think the governmental entity should have its immunity removed because they're best situated to deal and to provide the proper compensation, when people are injured or killed.
But that's a call for the legislature, isn't it?
Well, yes.
So as a practical matter, if you sue the individual employee who's maybe making a minimum wage, that's going to be essentially a waste of time in terms of collecting that judgment. So that's why you have to tag the municipality.
Absolutely. And again, it would have a chilling effect on people wanting to serve in those different capacities. So I think there's different reasons why, again, the employee should not be the one exposed to that liability, but the governmental entity is better situated, again, to be the defendant in these type of situations. But
I'm sorry. You finish your thought, please.
well, I was moving on to another.
Well, I might move you in a slightly different direction than you were going to go. But so if we were to hold that the Court of Appeals erred in saying that negligent act or omission includes recklessness and gross negligence, what, in your view, needs to happen in this case? The Court of Appeals analysis of the public duty doctrine, also kind of conflated under Hawkins County's position, I think conflated, negligence and gross negligence and recklessness. So is that something we would need to sort out? Would we need to send it back to the Court of Appeals for them to kind of redo that analysis in light of what we've said about the interpretation of the statute?
I would assert if this court ruled that the Court of Appeals erred, and again, conflating recklessness and gross negligence with negligence, this still would go back to the trial court because we have asserted a claim for negligent training and supervision, which removes the immunity of the governmental entities. And so we have removed immunity under the GTLA. And again, if you look at the Limbaugh case, which is similar, when we've removed the immunity under the GTLA, then we can travel forward with the allegation, the assertion of the reckless conduct of the employee, which removes immunity under the public duty doctrine. So the Lawson complaint should go forward even if the court ruled that it was an error by the Court of Appeals, again, to include gross negligence and recklessness as ways to remove immunity under the GTLA.
I guess I'm just trying to figure out what issues, how far we would need to go, how far this court would need to go in this opinion. I understand that there may be some claims that would go forward, so the case would necessarily go back in some form or fashion, but do we need to sort of simply decide the statutory question of whether a negligent act or omission includes gross negligence or recklessness, and then kind of send it back to the Court of Appeals to then reapply the public duty doctrine, overlay that on top of that statutory interpretation, or do we go ahead and resolve? Because there's some disagreement, of course, on the public duty doctrine as well, and exactly what claims can proceed. I think your adversary says that even if you have allegations of recklessness, that would not strip immunity for the negligent supervision claim, negligent training or negligent supervision claim. You seem to have a different view on that, though, right?
Well, first and foremost, again, I think the Lawson complaint asserts the negligent training and supervision that removes immunity under the GTLA. It asserts a claim for recklessness on behalf of those employees that removes the governmental immunity under the public duty doctrine. So first and foremost, this court should rule that the complaint can go forward based on that. Secondly, I think, what defense counsel is asking the court to consider and move back from what the Court of Appeals did is, again, their analysis of that negligence would include gross negligence and recklessness. And what I would ask the court to consider on that, again, is the definition of negligence itself is a deviation from the standard of care. And that is the foundational element in both gross negligence and recklessness. And so the legislative intent is to hold the governmental entities responsible and remove their immunity if they've deviated from the standard of care. And I think looking back in the Limbaugh case, Justice Holder's concurring opinion, I think there were some statements that she made there where she talked about the General Assembly has clearly expressed its intent to waive governmental immunity for injuries caused by the negligent governmental acts. Therefore, the governmental entity should be held liable for its own negligent employment practices, regardless of the nature of the underlying acts of its employees. To allow recovery for negligent governmental employment practices if the governmental employee acts negligently, but not if the employee acts intentionally, is a result contrary to common sense and the clear legislative intent. So, again, that's the second prong, I think, that the court is looking at. And I do not think that's an expansive reading of the GTLA or that statute, because the definition of negligence itself is a deviation from the standard of care. But I think the third thing that I would ask the court to consider is, again, the direction that was taken in that law. It's actually Lawson versus Maryville City Schools in the sidewalk case, is to consider the interaction between the public duty doctrine and the GTLA. And I think we are faced with situations where the trial courts, the Court of Appeals, we're all going to need the complicated diagrams to draw this thread of what we have to assert or what we have to prove in order for a plaintiff to move forward and seek redress. And again, many of those, it's absurd to think that the legislature, again, intended to remove the immunity from these governmental entities, but then to turn around and say, well...
Mr. Seeley, would you move back over to the mic?
Yes, sir.
So we can, yeah. Thank you.
So basically, as a plaintiff, you have to allege negligence to get immunity waived. But once you do that, the door slams in your face, basically, under the public duty doctrine. So then you've got to flip that negligence claim into one for recklessness to fit into an exception. Is that an oversimplification of what
No, Your Honor.
happens here? Which doesn't really make sense. That
Your Honor, it does not. And again, it's an absurdity that as an attorney, when I sit and try to explain that to Ms. Lawson or her son that's lost, his father, lost her husband, about that absurdity, again, that should be corrected. That
How
was
much
not the intent of our legislator to create those type of absurdities.
How much of that is at the feet of the court in Ezell? Because Ezell contemplated the GTLA, but really didn't analyze it in connection with it said, the GTLA didn't eliminate the public duty doctrine and adopted these exceptions, and there's no explanation about how it dovetails with the GTLA.
And I think that's the problem that courts have faced since Ezell was decided, Your Honor, is it was not analyzed at that time. And now we have all these different decisions where, again, when you look through...
Trying to make it fit.
Exactly. Mm-hmm. And that's what the courts have tried to do, and that's why we have decisions that are all over the place where, again, in Brown, reckless conduct is allowed to move forward, but really, how was immunity removed under the GTLA?
Because not all, as Ezell itself explains, that even if you assume that the public duty doctrine still applies, not all states have a configuration that has this recklessness exception to the public duty doctrine, and it's, my brain has been in a doom loop on this case trying to sort it out.
I suspect yours has too.
It's I can tell you, it's created a lot of anxiety for me to have to present that because many times I have been lost in that doom loop. But, again, I think you've hit what the courts have been struggling with since Ezell. And that's what I would ask the court to consider is, again, we've tried this analysis with the public duty doctrine and trying to make it somehow fit and work with the GTLA. And again, what I would argue to the court is the legislature has shown their intent that they want to remove immunity from governmental entities and their employees when they've deviated from the standard of care, with certain exceptions. That is the legislative intent. Trying to then impose the public duty doctrine and its exception results in too many absurd results. And that's, again, I think the Lawson versus City of Maryville case hit on that. And so I think the court should consider, should we be explaining to people that since you have a duty to everyone, that means you have a duty to no one? That's an absurdity that, again, we shouldn't be explaining to someone who's lost their husband. We shouldn't be trying to justify that. Clearly, the legislative intent was to remove the immunity in these certain circumstances.
Well, and I want to bring you back, to the text of the statute because, I agree this is a complicated area of the law, given this interplay between the GTLA and the public duty doctrine. But, our task is to interpret the words that the legislature has enacted. Many of the arguments that you're making, I don't disagree with them. I think they are better directed to the legislature than to us, because we have a statute that has been enacted by our General Assembly, and we've got to interpret that statute. So I want to bring you back to that and just ask you to give me your best argument about why the text of the statute supports your position that the GTLA strips immunity from municipalities for negligence, recklessness, and gross negligence.
Because the very definition of negligence is a deviation from the standard of care.
What are we to make of the fact that, you know, the statute also uses the distinct terms, you know, gross negligence, and, you know, that other statutes make this distinction as well?
Well, but specifically in this statute, if you look at 292205 and you look at Section 10 dealing with COVID-19, where it removes immunity for mere negligence, but says that, again, their immunity is removed if there's gross negligence. Well, certainly, again, they're drawing the line and saying you retain immunity for mere negligence, but if there's gross negligence, then you've lost your immunity. So, again, if you accept this argument that it's only gross negligence, does that mean that, again, at some point you'll have to make a distinction between gross negligence and recklessness with regard to a COVID injury? And I don't think that's what the legislature intended. I think they intended to draw the line between negligence there and then gross negligence and above. And there is a distinction that you can see there. But I
So
do
you're
think,
saying that when the legislature refers to a specific tort, that it necessarily includes kind of that tort and anything worse?
well, I think they specifically have said, since they've talked about gross negligence, they've entertained a scenario where clearly they mean for gross negligence to remove immunity. So they have set out these scenarios where.
So they were
under-
making that a floor for COVID cases?
Yes, Your Honor.
Okay.
But then removing immunity for gross negligence, and I would argue for reckless conduct.
Mr.
But-
Seeley, how would you have us modify the public duty doctrine to prevent an absurd result, such as this case may present?
I think the inherent contradictions that have been borne out since Ezell would warrant the overturning of the public duty doctrine. And again, the intent of the legislature is shown in the GTLA, and that should be followed. And I think that resolves so many of these absurdities that courts are dealing with, that people that are seeking redress against governmental entities are dealing with. And I think that makes good sense. And I look back at Justice Holder's opinion. We've created a situation between the GTLA and the public duty doctrine that just has too many absurdities. When we talk about having to draw a diagram and this, again, mind loop that you get into with exceptions within exceptions, that should not be the law in Tennessee. If we cannot explain, to the person who lost their husband, this is what the law is, and it makes sense. And it's so difficult to tell people, this makes no sense, but this is where we're at. And that's why I'm here before this court to ask you, again, we should not be in that situation. The legislative intent is to remove immunity from these governmental entities when there's been a deviation from the standard of care, except for those specific exceptions that they've set out.
So we need to scrap it. There's really no way to fix the problem without scrapping it. There's really no way to fine-tune it.
Your Honor, I don't think there is, and I think the cases, if you look, since Ezell, bear that out. We have cases that are all over the spectrum, again, trying to navigate this labyrinth. And that shouldn't be how we access our...
That's not interpreting the statute. That's wholly common law.
Well, the public duty doctrine.
Yes.
Yes.
That's what I'm talking about.
Yes, and that's why, again, I think that it should be overruled. That should not be the way we achieve justice in this state, is to have to navigate some type of labyrinth between these two different theories, the GTLA, the statutory, and then the common law with the public duty doctrine. This court has the authority to overrule the public duty doctrine. It's time that should be done.
You haven't asked us to do that. You didn't ask us to do that in your briefs, did you?
We did not address that specifically in the brief, but I think, again.
And that issue has not been briefed, whether we should overrule Ezell.
We addressed the contradiction, and again, the more research I do on this, the more preparation I do. Again, I don't know that there's any other result that addresses the absurdity that we're now faced with.
But so the answer to Justice Campbell's question is no, you did not specifically ask for us to overrule.
Not in my
Ezell.
brief, Your Honor.
All right. Thank you, Mr. Seeley.
Thank you for your consideration.
Mr. Ward, you have 10 minutes, but you don't have to use all of them.
Thank you, Your
It's a
Honor.
long drive back to East Tennessee.
That's right.
It is.
We're just thinking about you.
Let me start with the last thing that was touched on. Neither Ms. Lawson or the Tennessee Trial Lawyers Association has asked this court to eliminate the public duty doctrine. So that was not an issue that was raised before this court. But I would submit to you that there's not an inherent contradiction. There is not an absurdity. So the Governmental Tort Liability Act specifically contemplates that there are going to be situations where the entity will be immune, and in those situations, the employee will not be immune, or vice versa. So if the entity's immunity is lifted, then the employee has immunity under 292310B. So if it's a negligence situation and the entity's immunity is lifted, that employee then has that immunity, but vice versa. So if the entity's immunity stays in place, the employee can be sued, and what the statute says is the employee's liability will be limited to the same liability that the entity would have had unless certain heightened things are there. You know, some intentional element, some action for their own personal gain. So the statute itself contemplates that there will be suits that could be against the entity, could be against the individual. The public duty doctrine translates into that very well from the standpoint of this court saying previously, we don't want situations where sort of the discretionary actions of folks are going to be second-guessed unless there's a special exception that applies. And in that situation, the case was, Ezell was, you had a chief of police who saw a lady outside a bar and thought she was under the influence, and so prevented her from driving, but then another gentleman came out of the bar that he thought could drive and let her drive off. And then an hour later, they run into somebody and it results in a death. And the court analyzed the principles behind the public duty doctrine in detail. Did the court at that point actually go through every element of the GTLA and see how they would correlate? No. And I wish there had been a recklessness claim in there, because then we'd already have some guidance as we're talking about today. But I would submit that in a situation where it's a higher level of conduct, the legislature is not intending to make the governmental entity responsible for that higher level of conduct.
Well, let me just apply that.
Yes.
To, I don't know what the proof is going to be in this case. But, for example, in this case, the allegation is that there was negligent hiring and supervision. They didn't tell these employees what to do.
Correct.
They didn't say, if the road washes out with a mudslide, you need to close it. And so the allegation is negligent hiring and training and supervision. So if this employee just knew, realized, oh, the standard would be for me to close this road, but I need to call my best friend and talk to him a little while before I do it, or, just didn't care. And that duty would be deemed to the public at large, anybody who would come on that road. You're saying in that situation, no matter how reckless the employee is, that the governmental entity is not held liable?
Correct, Your Honor. The person that should be held liable is the one that consciously disregards that risk. So that,
even though the governmental entity, the allegation is, never trained him, never talked about it, just said, Cousin Bob, you're hired. Here's your cap. Go on out there.
Yes. So if Your Honor's saying, should the entity be allowed to be sued for
That lets the
negligence?
governmental entity off the hook for its own independent negligence?
Unless there's a
and-
special duty that applies. And there would be in certain situations. There would be in the mental health institution. There would be in some area where they've designed to protect.
And you think that that's what the legislature intended?
I don't think the legislature intended to punish governmental entities for reckless or intentional conduct of their employees. So I don't think this is a chilling effect from the standpoint of saying, okay, well, nobody's going to want to go to work there because they might get sued for their reckless conduct. But if an employee can get away with reckless conduct and instead it's just the entity that's going to be liable, you disincentivize the employee themselves not to engage in that kind of conduct.
But
So-
isn't this a two-step process? I mean, the allegation is, negligent hiring, and because of that negligent hiring, you have an incompetent employee here who's reckless.
Yeah, and I would go back to something that Justice Kirby said earlier. If it's really negligent hiring or training, and it's something that clearly the person should have known, I'm not sure how you get to the negligent hiring or training if it's that obvious that they're disregarding a known risk. So it's sort of that difficult position of, and we've had that in civil rights cases where they're trying to claim a governmental entity has a policy or custom of failing to train, and a judge has said, well, you don't really have to train a correctional officer not to go have sex with an inmate. It's one of those things that, they should know on their own. And so we've seen that kind of situation in a civil rights setting. And so what I would submit here is, from the public duty doctrine standpoint, if someone's engaging in this higher level of conduct, it's that employee, and that employee is the one that should be exposed for that higher level of conduct, not the governmental entity then being required to immunize that employee from that conduct. And would submit that avenue is there, that avenue can be pursued against, and we see those cases all the time where there may be different allegations and multiple defendants brought in because it's unclear which way the facts will truly go. So the only other thing I wanted to point out was that one of the cases the Court of Appeals didn't deal with at all was that Spearman case, and that case actually, this court denied permission to appeal in that case, and that became a published case as well. So unless the court has further questions, though, those are all the arguments I have. Thank you very much.
Thank you. Thank you, Mr. Seeley and Mr. Ward, for coming over here from, I believe, Johnson City and Greenville, respectively. And appreciate all you gentlemen for your kind attention today. I hope you learned something from this process. We're glad to do it and glad to see you this morning. May adjourn.
All rise.